Good evening, everyone. My name is Jim Lawrence. I'm the board chair of FxSMC County. Welcome. Welcome to everyone to this month's all hands meeting. Whether you're tuning in from your office, at home, or your favorite cafe, or still driving, we're thrilled to have you here with us. Like all of you, I've been really waiting and looking forward to tonight's meeting and hearing from our guest speaker. We're so grateful she's taken the time to share some of her wisdom as we continue our journey to achieve our mission, an independent civilian oversight board with an inspector general's office. In this fast-paced world we inhabit, few things are invaluable as opportunities to get together, share updates, and foster a sense of community. Your presence here tonight underscores your commitment to our collective goals and objectives embodied in our mission. As always, your insights, questions, contributions are welcome, but they're encouraged. After all, it's through collaboration and communication that we truly thrive. Once again, welcome. Thank you for being here. And let's make tonight's meeting another one of those to remember. Thank you.
And hi, I'm Nancy Goodban. I'm Executive Director of FxSMC, and I'm thrilled to be able to introduce as our partner spotlight, Kalimah Salahuddin. She's the founding member of the REACH Coalition. She's the Vice President of the Jefferson Union High School District Board of Education, past President of the San Mateo County School Boards Association. She served on the county's COVID-19 Recovery Council, and she currently serves on the board of the Housing Leadership Council of the county, as well as on CommunR. She's also been a board member for Habitat for Humanity for Greater San Francisco and a regular site volunteer there. She's currently employed at FxSMC as the DEI Community Programs Manager and is a mother to 3 wonderful adults. And we're thrilled to have you, Kalimah.
Hi, and I'm exhausted, every time I hear my bio, I get tired. Thank you so much for having me here. I am so happy to be in this space with everyone. I've had a rough couple of days, and so it's nice to be in a community space with people who understand the struggle. So I am the co-founder of the REACH Coalition, and that's why I'm here. Many people don't know about us, and that is kind of by design, but we have now are trying to become a little bit more forward-facing. REACH Coalition, I had slides, but I'm just going to talk. REACH Coalition is a group of elected officials of color and community-based organizations that are run by people of color. And we started during the COVID-19 crisis that is still ongoing. We're now dealing with the mental health issues of the pandemic. But when the pandemic first hit, there were elected official calls, and they held elected official calls every single day. And it was a week of those calls, and I knew that the community that I represented was going to be in trouble. When they had the discussion about what they were going to do, and they developed a plan, and there was a list of priorities, and equity was the last priority on the list. And so we knew right away, because of the response that always has happened in our community, if you don't come prepared with a certain set of resources and tools in San Mateo County, you cannot get assistance. And people think they are common, having access to the internet, having access to the computer, having a car or independent form of transportation, having housing that is stable. And we know that all of those things disproportionately affect people of color. And so when the pandemic hit, every single support or service was tied to one of those things, every single one. And so we decided to come together because, as normal in this county, when there is an issue or when there is a meeting of leaders, they allow one of us in the room, and we are there to represent everybody. So I would get invited, or Paul Bocanegra, who is also a member of REACH, I'll get invited, or Hector Camacho. one of those people would get invited and we would have to represent our entire community, all people of color, regardless of your background or race or cultural identity. And we decided to flip the narrative, and we were going to come together as a group and invite people to come and talk to us. So we did that, and we sent a letter stating these are the things that we wanted to happen in response to the pandemic. And we immediately received a response, and we've stayed in communication with the county since. We operate and advocate at county level issues and above, so county and federal. And because we're elected officials, we find it sometimes a little bit more beneficial to have the conversations one-on-one with other elected officials. Sometimes when there's a lot of pressure, and not to say that we shouldn't do that at times, you need a lot of people at meetings to make noise, but sometimes it's all good to also have the conversation behind the scenes to help people understand, because any human being, regardless of the issue, when there's a lot of people yelling or upset, you kind of get defensive. In San Mateo County, we have the award for defensiveness. We hate not being perfect here, and we have a really hard time being vulnerable. So anyone telling you that we're not doing something great becomes challenging. And the narrative that gets used is the loss of civility, making people uncomfortable here. All of those things are hard. So trying to put people in a space that they're used to and are comfortable with, and then having the conversations around equity that need to happen. REACH stands for Real Equity to Achieve Community Health. And that's what I want. I've lived in this county my entire life, and I've raised my children here. And during the pandemic, it rocked me to my core to watch someone who looked like my son walk down the street and be murdered for doing nothing. And my son's entire life, I have trained him on what to do, not if, but when he was stopped by the police. And then I watched the video of Chinadu Akobe, and I knew that nothing I would have taught my son, nothing I taught my son would have saved him that day. And it's hard to have those conversations with people. It's hard to have conversations with leaders. No one likes change. But the current attitude of civility is built on the backs of people of color. No one gives the priority to our feelings of unsafety, giving the priority to our uncomfortableness. We are forced to be uncomfortable so that everyone else can stay comfortable, so no one else has to change. And that narrative has to change. We have to be a part of that solution. I don't need you to solve the problems for me. I need you to include me. I need you to speak to us. And so that has been the main focus of REACH. Our members include, and I'll just go down the list. Like I said, Paul Bocanegra, Hector Camacho, who's a trustee of the San Mateo County Board of Education, James Coleman, who is the mayor of South City, Lizette Espinoza, who is a council member of the city of Redwood City, Eddie Flores, who is on the city council of South San Francisco, Maurice Goodman, who is the vice mayor of the city of Millbrae, Dana Johnson, who is the LGBT commissioner for this county of San Mateo, Clayton Koo, who's a former trustee with Jefferson Elementary School District, Andrew Lee and Rosie Tejada, who are on the board of the Jefferson Union High School District with me, Eva Rodriguez, who's on the North Fair Oaks Community Alliance because they're unincorporated. They're not able to have a city council. Cecilia Taylor, who is on the city council of Menlo Park. Lisa Teeler, who's the executive director of the Bay Area Health Advisory Council. Shara Watkins, who's a San Mateo Foster City School District member. Lihia Andrada Zuniga, who is a San Mateo Union High School District member. And our current member, who is now a sitting Board of Supervisor member, who we are super proud of that she was able to, when she was a part of REACH, that discussion led her to run for the Board of Supervisor and win. So these are the members of REACH, and our goals and things that we have worked on we've worked collaboratively with the county for the COVID recovery initiative and the response. We advocated and were able to get a county equity officer who was Shireen Malak Ghazali. And then we have continued to work with her. We were on the hiring team that helped pick her. And we've worked with Shireen, and today the county adopted an equity ordinance, something that we've been working for a long time. We no longer want resolutions. We want actual practices put in place that dictate equity and talks about what equity is: equity in hiring vendors, equity in the distribution of money, and collecting and keeping data to make sure that resources from the county are going to the people that need them the most. So to wrap things up a little bit, one of the immediate things we're working on right now is one of our members, Maurice Goodman, is being recalled in the city of Millbrae because he voted to support a family transitional housing project. It's called Project Home Key, that the county of San Mateo is advocating and working on across the county. What they do is they take old hotels, so a La Quinta Inn, hotels that are like the mini suites that have the mini kitchens already built into them, and they flip those. Instead of having to build new housing, they flip those into transitional homes, individual homes for families, and this one is going to be for families and seniors. And the city of Millbrae has pushed back. They are currently suing the county for building less than 60 units of housing for homeless families and seniors. And they are now turned in enough signatures and the process of recalling the 2 Millbrae City Council members who voted for housing. And someone who has been homeless myself, I would not be sitting here as a single mother with 3 young kids if I didn't have transitional housing to help me get back on my feet. So we're asking, thank you, Gina. Gina already put it in there for me, to come. We have the kickoff on Saturday, May 11th at 11 a.m. It's going to be in Millbrae, 126 North Rollins Road. There's plenty of parking at the BART parking lot. It's in the same like BART parking structure. You can park there and then walk right over next door, and that is where the kickoff is going to be held. If you can't come, and you just still can register on that page and see how you can help. People can't get recalled for helping people find housing. Like, are we, who are we at San Mateo County? Is this a place that is supposed to be open for everyone? And the stigma around homeless people, it saddens me that that is still language. The language around homeless people is still being used. The next thing is that we are going to be offering, and for Pride Month, we're going to be offering SOGI training, which is sexual orientation, gender identity, and expression, by one of our members, Dana Johnson. And I will also put that in registration link in the chat, and it'll be held over Zoom. So if you would like to join us to learn a little bit more during Pride Month about how to speak, talk to, make sure that those that are have on the spectrum of sexual identity or gender can be, pronoun usage, using language that's inclusive. Please join us, because in the end, I want to ensure that San Mateo County is a place that's comfortable for everyone. That's the way it should be. I want to feel like I belong here. So thank you, Nancy, that this is me speaking on my own. But I also feel like if we don't support the people that support what we want, then we won't be able to move forward. So thank you so much for giving me the platform, and I turn it back over to you.
Good evening, everyone. My name is Paul Bocanegra. I am a board member for FxSMC San Mateo, and I have the honor of introducing our Judge LaDoris Cordell. And I have a brief bio that I'm going to read to introduce this fabulous speaker that we have tonight. Judge Cordell received her law degree from Stanford in 1974 and was the first lawyer to open a law practice in East Palo Alto. In 1978, she was appointed Assistant Dean for Student Affairs at Stanford Law School, where she implemented a successful minority admissions program. In 1982, Governor Jerry Brown appointed her to municipal court judge, and she was elected to Superior Court in 1988, making her the first African-American woman on Superior Court in Northern California. After retiring from the bench, she returned to Stanford as special counselor to the president for campus relations. Judge Cordell is a longtime advocate for greater transparency into law enforcement abuses and misconduct. She was the independent police auditor for San Jose from 2010 to 2015. She served to San Francisco's Blue Ribbon Panel on transparency, accountability, and fairness in law enforcement in 2015. She is a frequent guest on CNN, MSNBC, and NPR, featured in several documentaries and the recipient of many awards and the author of Her Honor. She also served on the Palo Alto City Council. Absolutely impressive. Please take the floor. It is an honor to introduce Judge LaDoris Cordell. Thank you.
Thank you so much, Paul. And thank you, Kalimah. I did not know about the REACH Coalition, so thank you so much. I've already learned quite a bit just sitting here. So thank you for inviting me to speak to you very briefly. And it's Karina, if you could put the first image up for me. Thank you. So what I have been asked to do is to talk about policing in America. And this is really, really brief look at policing in America. So I firmly believe, and I think all of you all do too, that you cannot make policy, you cannot make change unless you have information and understand how systems work. So this is a very short primer on policing, but I think it's an important one as you all move forward and deal with issues such as independent civilian oversight. Please go back. That's fine. All right. So next image. The first modern police force was created in 1829 in London by this man, Sir Robert Peel. His British police force began with about 3,000 officers in London, and he chose the color blue to give blue uniforms to police to distinguish them from the red that was worn by the British military. Next image. New York adopted the London police model and established a paid professional police force in 1828. What you're looking at is a drawing of what the very first uniforms looked like. So again, this was in New York, the very first place to have a professional police force. Next image. Full uniforms were adopted in New York in 1853. So New York City was the first in America to have a modern style police department. They had 800 officers, and then followed shortly thereafter in Boston and then in Philadelphia. And today there are approximately 18,000 police agencies in this country. America's early police departments, and this is really important, they patrolled unarmed and without any uniforms, and they were required to live in the wards that they patrolled. So they had their communities, their homes there, so they knew the people with whom they were interacting. And in some neighborhoods in America, officers ran soup kitchens, and the unhoused were allowed to actually sleep and bed down at night in the police stations. Police during this time, the beginning part, were more service agencies than they were law enforcement agencies. Next image. And that all changed when the police chief in Berkeley turned policing in America from this paternalistic service-oriented job into a profession. Chief August Vollmer, he served from 1905 to 1932 as the police chief in Berkeley. He detested community policing. And this is the man that pioneered the use of police radios, squad cars, police on bicycles, lie detector tests, crime labs. So policing's focus under this person became a profession dedicated to crime control. And this crime control focus, what it has done is isolated officers from the residents of the communities they patrolled. And it basically has limited their interactions with people to today to basically traffic stops, pedestrian stops, and interrogations about crimes. The optics of police cars patrolling neighborhoods today has created a perception in some communities, especially in low-income communities and communities of color, a perception of police as this hostile occupying force, and the perceptions that in some instances have become more than perceptions, they are a reality. Next image. So I want to talk just for a bit about culture, police culture in America. So what is this culture that we have today? Next image. Within a police department, culture eats policy for breakfast. You can have a perfectly worded policy, but it's meaningless if it just exists on paper. These were the words of J. Scott Thompson, former police chief of Camden, New Jersey. So this is from someone who spent his career in policing. And this is what he says: it's the culture that will eat policy for breakfast. It's the culture that drives everything. So in policing, there are unions, and they never call themselves unions. They are fraternal orders, the benevolent orders, but they are unions that are different from, I think, all other unions in that all other unions kind of have a sense that other unions, you help each other out. These police unions are very insular. They take care of their own. And it is, in my view, a strong union and a strong union leader in policing that creates the culture of a police department. And that is a problem today because, in general, police unions almost uniformly oppose reform efforts. So, for example, in San Jose, where I was the independent police auditor for 5 years, when a group of 9 police officers were discovered to have posted virulently racist and Islamophobic remarks in a secret Facebook group, the union's president immediately defended them. Next image. The largest police union, the Fraternal Order of Police, has more than 2,000 local chapters and nearly 350,000 members. The Fraternal Order of Police lobbies for officers through collective bargaining agreements or enacting state laws. So, for example, the language of the contract with the police union in Chicago required misconduct records of police officers to be destroyed every 5 years. In Cleveland, it's 2 years. In California, misconduct records are destroyed every 6 years. And what is so shocking to me is that in no other profession are misconduct records permitted to be destroyed. How can you hold officers accountable if the records of misconduct don't exist? So there might be records for an officer, but if it's 5 years down the road or 6 years in California, they're gone. So you have no idea really who you're dealing with, at least the public doesn't. And I absolutely believe that this is basically unheard of in any profession. And I don't think, by the way, it should be a part of policing in America. A 2016 survey by the Police Executive Research Forum found that police agencies spend a median of 58 hours training recruits in how to use a gun and 49 hours on defensive tactics, but just 8 hours on de-escalation and crisis intervention. Therein lie some of the problems. Next image. I have my own army in the NYPD, the New York Police Department, the 7th largest army in the world. Those are the words of New York City Mayor then, Michael Bloomberg. The problem with this, police are not soldiers, but the culture sends a clear message that they are. Case in point, in Johnston, Rhode Island, that has a population of 29,000 people. I live in Palo Alto, and we have a population between 60 and 70,000. So this little place in Rhode Island, 29,000 people, and it only covers 27 square miles. Its police department has $4.1 million worth of surplus military gear from the Pentagon. And what does that mean? 30 M16 rifles, 599 M16 magazines containing about 18,000 rounds, a sniper targeting calculator, 44 bayonets, and 12 Humvees. Makes no sense. All right, so that's kind of the background going in. Next image. So we're next going to talk, and this is really what I care about so much, and that is how the law creates superpowers in policing. Next image. The U.S. Supreme Court creates the laws that apply to policing for everyone in the country, for all the states. And for the last more than 50 years, since say 1967, the Supreme Court has endowed law enforcement with superpowers, and lots of them. Because of our time limit here, I'm going to focus on 6 of them. There are more, but I want us to look at these 6. Next image. In 1967, the Supreme Court decided Pearson versus Ray, and literally invented the doctrine of qualified immunity that protects police officers from civil liability lawsuits when they're accused of using excessive force. Next image. So these are the facts from this case, and it's so important that you understand what gave rise to these cases. And I didn't make up these facts. I took these words, these facts, from the opinions and from the dissents in these cases written by the Supreme Court. So here's what happened in Pearson versus Ray. A group of 15 white and black Episcopal clergy people attempted to use segregated facilities at an interstate bus terminal in Jackson, Mississippi. That was in 1961. So they were all 15 were arrested by 3 police officers from the city of Jackson, Mississippi, and they were each charged with a misdemeanor. It was a misdemeanor in 1961 to congregate with others in a public place and refuse to move on when ordered to do so by a police officer. So they were convicted, and after a trial, and they were sentenced the maximum. Each of them got 4 months in jail and a fine of $200. So that's the criminal case. They then sued the police officers for false arrest and imprisonment. And the U.S. Supreme Court threw that lawsuit out. And in doing so, next image, came with the now legal premise. It is what I call superpower, that officers are immune from civil lawsuits if they demonstrate that they acted in good faith and had probable cause to act. And that decision came out in 1967. And that's when this term, qualified immunity, that's the genesis of this. So it didn't even exist before this case. And it's based on a group of interracial group of people who tried to integrate a segregated bus terminal. Okay, next image. So that was superpower number 1. So superpower, before we get to it, this is the next one, stop and frisk. And this superpower comes out of this case, Terry versus Ohio, which was decided by the U.S. Supreme Court in 1968. Next image. All right, so here's the facts. John Terry, and by the way, any of these court decisions, it always usually has the last name of, if it's a criminal case, of the defendant. And then if they're suing, if it's against the state, then it's Ohio, or it could be about a city. So this was the state of Ohio. So this is John Terry. And he was one of 2 black men that had been stopped by a police officer in Cleveland, Ohio. And the officer gave this as his reason for stopping them. And this is a direct quote from the case. "They didn't look right to me at the time." So the 2 black men, what had they been doing? They've been looking into store windows during the daytime in the downtown business district. So we get from this a Terry stop and frisk policy. And they've been used this policy has been used almost exclusively to target black and brown people. Next image. So this is superpower number 2, came about in 1968. So before this stop and frisk power, the court had allowed such stops only when an officer had probable cause to believe that a crime had been committed. but that's went out the door in 1968. So the stop and frisk, if the officer has a reasonable suspicion, and the suspicion in the case was they didn't look right to me. Two black men looking into a store window. Next image. Notably, Justice Douglas was the only dissenter, and I think his words were so prescient. He wrote in his dissent, if the police can pick him up whenever they do not like the cut of his jib, if they can seize and search him in their discretion, we enter a new regime. And was he ever right? All right, next image. So we're going to go on to number 3 here. And this is the objectively reasonable standard superpower. It was brought about in a case of Graham versus Connor. And this case was decided in 1989. Next image. On November 12th, 1984, DeThorne Graham, a black man who was a diabetic, felt the onset of an insulin reaction. So he asked his friend, William Berry, also a black man, to drive him to a nearby convenience store so that he could purchase some orange juice to counteract the reaction, to get some sugar, right? So Berry agreed, but when Graham entered the store, he saw a number of people ahead of him in the checkout line. He was concerned about the delay, so he hurried out of the store and asked his friend to drive him to a friend's house instead. Connor, and that's the Connor in this case, Graham v. Connor, was an officer of Charlotte, North Carolina Police Department. So Officer Connor saw Graham hastily enter the store and leave the store. So the officer immediately became suspicious that something was amiss and followed Berry's car. That's the friend who was driving him. About a half a mile from the store, Connor made an investigative stop. He pulled him over. And although Berry told Connor that his friend Graham was simply suffering from a sugar reaction, the officer ordered Berry and Graham to wait while he found out what, if anything, had happened at the convenience store. So when Officer Connor returned to his patrol car to call for backup assistance, so first he goes to his car, calls for assistance, and he intends to go back to the store to check it out. Graham gets out of the car. He runs around it twice and actually finally sat down on the curb, and then he passed out very, very briefly. And in that ensuing confusion, and again, I'm taking all of this from verbiage from the actual opinion, right? So in this ensuing confusion, a number of other Charlotte police officers arrived, the backup, on the scene in response to Officer Connor's request. And one of the officers rolled Graham over. Remember, he's seated on the curb, had passed out briefly. He rolls him over on the sidewalk, cuffed his hands tightly behind his back, ignoring his friend's pleas to please get him some sugar. And another officer said, and I quote, "I've seen a lot of people with sugar diabetes that never acted like this. Ain't nothing wrong with the MF, but drunk. Lock the son of a bitch up." Next image. So several officers then lifted Graham up from behind. He's cuffed behind his back, carried him over to his friend's car, placed him face down on the hood. Graham then regains consciousness, and he asked the officers to check in his wallet for a diabetic decal that he always carried. And in response, one of the officers told him to shut up and shoved his face down against the hood of the car. 4 officers grabbed Graham, threw him headfirst, threw him headfirst into the police car. A friend of Graham's brought some orange juice to the car, but the officers refused to let him have it. Finally, Officer Connor received a report that Graham had done nothing wrong at the convenience store, so the officers drove him home and released him. Now, next image. I want you to see the injuries that he suffered. Graham sustained a broken foot, cuts on his wrist, a bruised forehead, an injured shoulder, and he also developed a loud and continuous ringing in his right ear. So Graham filed a lawsuit against these individual officers, including Officer Connor, alleging that they'd used excessive force in making this stop. The case was tried before a jury. Remember, this is North Carolina. The trial court granted the officer's motion for a directed verdict. What this means is Mr. Graham put on a case before the jury, and the judge didn't even allow it to go to the jury. The judge said, I've heard enough, and I'm going to just direct the verdict in favor of the officers and basically against Graham, and found the officers not liable. Remember, this was civil. They're suing him, finding that the amount of force used by the officers, and I'm quoting the trial court judge here, the amount of force used by the officers was, quote, appropriate under the circumstances. And going further, there was no discernible injury inflicted. And the court held the force used was, quote, not applied maliciously or sadistically for the very purpose of causing harm, but in a good faith effort to maintain or restore order in the face of a potentially explosive situation. Unbelievable. Next image. So the case eventually, this lawsuit now that got thrown out, went to the Supreme Court. And the court held that a claim of excessive force by law enforcement during an arrest, a stop, or other seizure of a person is subject to the objective reasonableness standard of the Fourth Amendment. In other words, police can use excessive or even deadly force if it is objectively reasonable from the officer's point of view. So the Supreme Court sent it back to the trial court. The trial court's verdict was vacated and then sent back to the trial court for reconsideration given this new definition. So I call this superpower number 3. Given the facts of this case, the court said, well, no, we need to determine whether or not it was the use of force against this man was objectively reasonable. Amazing to me. So, and again, it's from the officer's point of view. All right, next image. So now we go to the case of Wren versus US. This was 1996, and it's all about pretext stops. Next image. So let's talk about what happened here. On the evening of June 10th, 1993, plainclothes vice squad officers, the District of Columbia, we're in Washington, D.C., Metropolitan Police Department, were patrolling a high drug area of the city in an unmarked car. The officers saw a dark Pathfinder truck with temporary license plates that stopped at the intersection for more than 20 seconds and then turned suddenly to its right without signaling and sped off. So the officers stopped the truck, approached the driver, and saw 2 bags of cocaine in the passenger's hands. That was Mr. Wren. So they were both black men, were arrested and convicted of drug charges. The officer claimed that he approached the vehicle, he stopped them to give the driver a warning concerning their stopping too long at a stop sign, more than 20 seconds, mind you, and failure to use a turn signal. So Mr. Wren said, no, the stop was a pretext to stop them and search the car. Next image. So in 1996, the U.S. Supreme Court ruled against these 2 black men, finding that pretext traffic stops are constitutional. So policing is, for the most part, all about traffic stops, okay? Police officers pull over more than 19 million vehicles a year, making vehicle stops the #1 reason for contact between individuals and the police. So in Washington state, this is really fascinating. Pretext stops were banned in 1999. So the court says they're constitutional, but individual states can say, no, we're not going to allow them. Okay, so the state of Washington in 1999 banned pretext stops. And they banned them when their own state Supreme Court ruled that the stops were unconstitutional. So you have the U.S. Supreme Court, but then you have the Supreme Court of Washington state saying, we think they're unconstitutional, therefore they're out. That was 1999. But then in 2012, the court in Washington now, Supreme Court, reversed course and found pretext stops constitutional. And that's because the members of the court changed, became more conservative, right? So what's interesting is that researchers looked at stops by the Washington State Patrol in the period where pretext stops were not allowed to those made after they were reinstated, okay? So you got these 2 groups, when it was unconstitutional, no stops allowed, pretext stops, and then when it was back in. So they studied the difference. Sure enough, racial disparities rose significantly when troopers were given legal authority to stop drivers on a pretext. And just another note, in California, we have, there was Assembly Bill 953. It was called the Stop Data Collection Law. And in California, all law enforcement agencies are required to annually report their stop data, traffic stops, to the state attorney general's office. And data includes, this is what every law enforcement agency has to now report annually: the kind of stop, a vehicle or a pedestrian stop, reason for the stop, the race, age, and gender of the person stopped, the conduct of the stop, meaning did they order somebody out of the car, sit on the curb, handcuffed, sit in the cop car. They have to report if there was a search or a seizure, what was uncovered, was the person cited, arrested, or released without any charge, and also the length of the stop. So it's important to know that this is now a requirement, although there are police agencies pushing back against it and still not complying. All right, so we just saw the superpower number 4, pretext stops. Next image. Again, we're going to cover 6. This is number 5. So this is making arrests for minor traffic violations, another superpower here. And this came about in the case of Atwater versus City of Lago Vista. And this was in 2001. Next image. These facts are amazing here. Gail Atwater was stopped for seatbelt violations when she was riding with her small children in Texas. The officer was loud and accusatory from the moment he approached her car. Atwater's young children were terrified, they were hysterical, yet when she asked the officer to lower his voice because he was scaring the children, he responded by jabbing his finger in her face and saying, "You're going to jail." Only the intervention of neighborhood children who had witnessed the scene and summoned one of Atwater's friends saved the children from being hauled to jail with their mother. So the officer handcuffed Ms. Atwater with her hands behind her back, placed her in the police car, and drove her to the police station. And ironically, he did not secure her in a seatbelt for the drive. So at the station, Atwater was forced to remove her shoes, relinquish her possessions, wait in a holding cell for about an hour. A judge finally informed her of her rights, the charges against her, and released her when she posted bond. She then returned to the scene of the arrest only to find that her car had been towed. Next image. Atwater, and again, I am giving you this information directly from the words from the opinion in the case and from the dissents, okay? Atwater had been driving, these are the facts now, very slowly, approximately 15 miles an hour in broad daylight on a residential street that had no other traffic, nor was she a repeat offender. Until that day, she had received 1 traffic citation in her life, a ticket, more than 10 years earlier for failure to signal a lane change. So she eventually pleaded no contest to the seatbelt violation and paid a $50 fine. She sued, here we are, civil again. She went to court and sued, claiming that her warrantless arrest for a minor violation, remember that's not having on the seatbelt, and carried only a $50 fine. So that arrest violated her Fourth Amendment right against unreasonable seizure. Well, in 2001, the court ruled in favor of the city, ruling that the police can lawfully arrest, handcuff, take to jail someone, even if the punishment for the violation is a small fine. Next image. Interestingly, 4 justices, O'Connor, Breyer, Ginsburg, and Stevens, although O'Connor's the one who wrote this dissent, the other 3 joined in with her. And she wrote this: the Fourth Amendment guarantees the right to be free from unreasonable searches and seizures, and that the arrest of Gail Atwater was a, quote, pointless indignity that served no discernible state interest. Amen to that. However, that was the dissent. There were 4 of them, and 5 voted the other way. And of course, one of them was Clarence Thomas. Next image. All right, so that is the superpower number 5. Police can lawfully arrest someone for a traffic violation where the punishment is a small fine. Next image. Now we get to superpower number 6. I'm going to wrap it up here. And this is the case of Frazier versus Cupp, decided in 1969. Next image. So, acting on a tip, Oregon police interrogated Martin Frazier, a 20-year-old U.S. Marine, about his possible involvement in a murder. Frazier, along with his cousin, were seen at a bar with the victim before the murder. Well, during the interrogation, the police lied and told Frazier that Rawls, that is the cousin, his cousin, had already confessed and implicated him in the murder, and Rawls had done no such thing. Frazier denied any involvement in the crime. He suggested speaking with a lawyer, but the police continued to question him, and the police elicited a confession, which was used against him at trial. He was convicted of murder, then his cousin pleaded guilty to murder as well. Next image. And here's what the court ruled, and I believe this was a unanimous decision. The fact that the police misrepresented the statements that Rawls had made is, while relevant, insufficient in our view to make this otherwise voluntary confession inadmissible. These cases must be decided by viewing the totality of the circumstances, and on the facts of this case, we can find no error in the admission of petitioner's confession. Next image. So this was superpower number 6. Police can lawfully lie to suspects to obtain confessions. They're allowed to do it. And again, it's based on the totality of the circumstances. But that is basically superpower number 6. Next image. So I want you to see some of these superpowers when they were on display. So they were on display in 2014 when Eric Garner was stopped and arrested under the Terry reasonable suspicion standard, remember that, for selling one loose cigarette. So again, Terry gave police that power to do that. Under the Graham case, superpower number 2, the police could use significant force if they thought Garner was resisting arrest, and if the police thought the proportion of the force was objectively reasonable. So as a result, Officer Pantaleo, who used a chokehold on camera that killed Mr. Garner, has never been charged with a crime. Next image. So what is the fix? There's much to be done. And again, I've just touched the surface in the time that we have. So in my view, the first step to doing anything is to be informed, which is what you all do, Fix in San Mateo County. It's important to vote. As you all know, I don't need to even, say anything more than that. It is important that we, right, Paul, run for local offices and that we form alliances. This is so important, that we involve our young people, and basically the very end, we all have to be upstanders for justice, not bystanders. Bystanders are the ones stand by, they watch everything, they complain, and in my view, bystanders are complicit. Everyone has to be an upstander in this journey. Next image. So I thank you all, and let us continue to move onward.
Thank you so much, Judge. We got a lot of great questions, and there's been a lot of interest and a lot of clapping I can see for you. Appreciate it. Beth asked really at the beginning, she learned so much from your book, her honor. Do you have plans for another book? I
don't at the current time. I've been kind of busy doing some interviews about the trial that's going on. And I'm just thinking about what I might do. But this was my heart. This was about what it's like to be on the bench and to deal with the pressures of being a trial court judge. So thank you for even raising that.
Great. And then Elsa had a question. What do you think of the civilian oversight of law enforcement in San Jose, and what might you like to change about it over time?
Yeah, thank you for the question. I was the independent police auditor for the city of San Jose for 5 years, 2010 to 2015. It was an eye-opener. I learned so much about policing and how important independent civilian oversight of law enforcement is. There are very few such agencies in the country. And generally, when efforts are made to bring independent civilian oversight to law enforcement agencies, there's tremendous resistance from the police unions. The oversight in San Jose actually started in the 1980s, and it has somewhat evolved. It's basically a hybrid, but my concern is that the office has really no power to investigate independently. So the police department internal affairs unit investigates, and then our office, or at the time, my office then, would review the investigation to ensure that it was objective and that it was fair. But that, even if we found it not objective and not fair, all we could do was push back a little, but we couldn't actually make change. Maybe, to direct them to go redo this investigation or to talk to someone else. So it was a hybrid. It was a compromise of people who wanted an independent oversight and those who did not. So there's a lot that I think could be done, that I know can be done to do better in San Jose. But while I was there, I found a very good way to bring about change is to be as transparent as possible about what law enforcement is doing. Because when the public finds out, then there's a real push. And I'll give you an example. After Eric Gardner's death, I checked the duty manual for the San Jose Police Department, and there was no reference at all to chokeholds. So my thinking was, why wait for something horrible to happen? Let's have a rule that prohibits chokeholds. Seemed to be no problem to me. We proposed the rule and immediately got pushback from the union saying, well, we may need to use them. So we went, we're very public with our recommendations. So it ended up becoming a part of the duty manual. However, there was sufficient pushback such that it's in the duty manual. It says chokeholds are prohibited except when circumstances warrant them. I mean, what is that? So it's part of the struggle, but I implore you all, don't get discouraged. Do not become discouraged. That's the way systems are, and particularly in policing.
And I think that's evident from your last slide of onward and continue the fight. So Jerry wanted to know, Jerry 3 was asking, do you think the Graham standard is really an objective standard, or rather a muddle of conflicting criteria that allows judges to make up reasons to support any police action they approve of?
Yes. Yeah, I mean, it's a problem.
We'll leave it at that.
Yeah, it's a problem. I mean, and the problem should be obvious.
Okay, and one last question and then a comment. Well, Kalimah said that if you'd like to run for office, please let her know. They can help.
Been there, done that twice, not doing it again.
Okay.
So I ran for the judgeship and I ran for city council. I've been in it, and no. I've done my thing.
Allison like to know, is it possible to change some of these superpowers at a state level with the state Supreme Court? Are any likely to change soon?
Yes. This Supreme Court, there's 7 on the California Supreme Court. 5 of them are people of color. 2 of them are LGBTQ and out. This is the most diverse Supreme Court we've ever had. Thank you, Gavin Newsom. So this is a court that recently held, and someone mentioned this before I came on tonight, and I'll pull it up, recently mentioned that the California Supreme Court just ruled that police cannot stop somebody or detain them if they see the police and then suddenly just walk away, right? And I'm going to pull it up. I thought I had it all set here, but I will pull it up right now. And this is amazing. And I was reading, by the way, the concurring opinion. So it's in the LA Times. I'm looking now. People can't be detained just for trying to avoid the police. Police, and I'm reading just the first paragraph, but I want to read you the response from the police union. Police officers cannot detain someone on the street just because that person tries to avoid contact with them. And the California Supreme Court ruled that on Thursday. So the decision has immediate implications for police officers working all across the state, restricting the grounds on which they can stop and hold people for questioning, okay? So as I was going through this article, and it was a unanimous decision, by the way, on the court. And one of the justices, Kelly Evans, an associate justice, she's African-American and she is LGBTQ. And she's the newest member of the court. I'm going to give you just a part of her concurring opinion. It was joined by 4 other justices. Many individuals, including particularly people of color, commonly hold a perception that engaging in any matter with police, including in seemingly casual or innocuous ways, entails a degree of risk to one's safety. Evans then listed the names of 35 people killed in interactions with police in recent years, including Michael Brown, Tamir Rice, Freddie Gray, Stephon Clark, Breonna Taylor, and George Floyd. And then she wrote, due to this searing history and the present day experiences of far too many people in the United States for generations, legions of parents in minority communities have given their children the talk, detailing survival techniques for how to navigate interactions with police, all out of fear of how an officer with a gun will react to them. All right, so she wrote more, and it's worth reading. But I want to tell you, this is the quote from the police union. And this brings up my point here. In a statement to the Times, the LA Police Protective League, that's their union, defended its officers' actions in the case. For most residents, let me give you the key part I want to give you. Yeah, here it is. Yet in their infinite wisdom, California's out-of-touch Supreme Court overturned 2 lower court rulings that found the officers acted lawfully and sided with the drug and gun possessing owner of the illegally parked car to further cement California's criminal justice system as the joke it is. So that's their attitude. Again, you have to read the facts of the case. I'm not going to go into it. But really interesting where we are here in California. So change can happen from our Supreme Court in the state, but also local jurisdictions. Cities can do all kinds of things in terms of passing ordinances. There are ways to do this, and people who are doing this in cities need to be talking to each other.
Thank you so much for a very intriguing and heartfelt session. And I'm going to turn it over to Nancy as she leads us out of the session. Thank you.
Thank you.
And thank you so much, Judge Cordell. If this has not inspired you, it should have, and I posted in the link how you can help. We have a booth at the San Carlos Hometown Days, and so I posted a link in the chat. You can sign up to volunteer. It'll just be fun, hang out there for a couple of hours and say hi to people. Also incredibly huge, the California Coalition for Sheriff Oversight, which is multiple counties. We're having a public launch June 4th. It's co-sponsored by the California League of Women Voters and ACLU Northern California and the county coalitions from Alameda, San Mateo, of course, Alameda, Marin, Monterey, and Santa Cruz as well. And there's a sign-up link for that. There's going to be a really good panel of somebody who's a board member of NACOL, the National Association for Civilian Oversight of Law Enforcement. He's also on the Sheriff Oversight Board. That's Jason Wechter. There's a panelist from who is running the Sonoma County Inspector General program, and that is John Alden. And we have a couple of people from Sonoma County here. And there is someone who is from the ACLU Northern California talking about Sacramento oversight, county oversight of the sheriff as a case study, and that is Marshall Arnwine. All of them are powerful, and you'll hear a 1 minute or 2 minute blurb from the active counties. So please sign up for that. And also June 22nd, we're having an in-person event at Central Park, and it's in San Mateo at 2 o'clock. It's a picnic. It is to celebrate Juneteenth and also to honor Maurice Goodman, who is the acting branch president of the local NAACP. He's also the vice mayor of Millbrae, and we're tying both those together just for fun. You can sign up for all those. And I put a donation link in too, and we're getting you out of here at 8:01. Thank you all for coming.
Thank you so much.
Thank you.